Good morning. It's great to see such a good turnout today and so many participants at today's webinar. By way of background to this webinar, we welcome this morning not only BCSA members, but people from across the construction industry, which is fantastic to see. This webinar came about as a result of BCSA's regular feature in Building magazine, Costing Steelwork, and an article I wrote for the June 2025 edition entitled Ditch the Risk Switch, in which I offered 5 ways to improve the way standard form contracts are used on construction projects. In return for the feature, we give this a free industry webinar. The article in itself came from my work with the Conflict Avoidance Coalition group. If you haven't heard of it already, the group is in a number of leading professional bodies who've got together from construction engineering and pledged to help the industry to reduce the costs of conflict and deliver major infrastructure and property development projects on time and on budget. One of the aims of the group is to get as many organisations as possible to sign up to the Conflict Avoidance Pledge, and the aim of the pledge is to drive a sea change in the industry and embed conflict avoidance mechanisms in contracts and in contract administration. Also, as part of the contract group, we would like to encourage the use of unamended or less amended standard form contracts, or at least to move away from the wholesale risk switching which goes on in most sets of amendments and which we'll be focusing on today. The construction playbook says that inappropriate allocation of risk remains one of the main concerns of suppliers looking to do business with government. It's also one of the most frequent issues raised by the National Audit Office in their audit of government contracts. A Conflict Avoidance Week was held in March, which was a social media-led campaign to raise awareness. And as part of that week and for the subsequent week, I put together a 10 clauses in 10 days campaign where I focused on one type of risky contract clause a day and discussed it in detail. Today, I'm going to focus on 5 different clauses and contract amendments, really from a specialist subcontractor perspective, although similar concerns may also apply if you're a main contractor. So on to BCSA. I am actually addressing mostly BCSA members who've signed up, so thank you for that, so many of you have. But I'd also give a wider introduction as this webinar is being recorded and will be available publicly on YouTube afterwards. At BCSA, among other things, among many other things, we provide free member webinars and contract advice. And if anyone afterwards would like to email or call and ask about BCSA membership, or indeed if you are a BCSA member and you can't get access to some of the resources I mentioned on here that are available on the website, then please do get in touch. So for those of you who don't know me or much about BCSA, BCSA is the British Constructional Steelwork Association. Our members are steel fabricators, erectors, makers, stockholders, and those who work alongside them, such as from main contractors to metal deckers to software providers. I've worked for BCSA as Legal Director and Company Secretary for over 7 years now, as advisor both to members and to the business. My background is in private practice as a construction and contract lawyer, and also working in-house for a main contractor. So I kind of seen things from contract clauses from all sides of all different sides. So on to the next slide. As for the contents of the webinar, we've got about an hour set aside. Hopefully it won't take quite as long as that. But in this webinar, I'm going to look at 5 common amendments to JCT contracts, which switch the intended risk around totally from the way the standard form is drafted. I'll try to take some questions at the end. If you do have questions, please type them either in the chat function if you can, or Q&A if you can see it on the screen. I can't see that on my screen. If I don't get through all the questions, or you'd rather email me or call afterwards, by all means, please do so. I'll repeat my details then at the end, and we can pick this up afterwards. So, on to the first issue of design risk. The first cause I want to discuss is a major design risk switch. There are a number of ways JCT contracts are amended which concern design risk, and where to look for that is very much usually in the first part of the contract. Sometimes it's in the articles, often several amendments to section 2 of the contract. This one is an amendment, quite a doozy of an amendment to clause 2.82. I'm just going to focus on this one for now. Also, if you want to have a look at my LinkedIn, I do go on to talk about discrepancies and divergences and how those clauses are amended in the 10 clauses for 10 days discussion. I think that was on day 2. So there is more discussion about design risk on there. So in this one, the contractor shall be responsible for the whole of the design of the subcontractor's designed works. The subcontractor shall adopt and be responsible and liable for the contractor's requirements and warrants that he has fully and properly examined, checked and verified and made all necessary inquiries as to the adequacy and the completeness of the contractor's requirements and any and all designs and other information provided to him in relation to the subcontractor's design works, including before and or after the date of this subcontract and or contained herein, and shall adopt, take over and ensue responsibility for the same, and clauses 2.9 and 2.10, and the subcontractor's rights and remedies under this subcontract shall be construed accordingly. The original clause, completely different. The subcontractor shall not be responsible for the contents of the contractor's requirements or for verifying the adequacy of any design contained within them. I can see why this clause comes about, particularly as someone who used to draft main contracts from a developer perspective. There's often a similar amendment in the corresponding main contract whereby the contractor takes responsibility for the employer's requirements. So it's a direct pass down to the subcontractor from the risk switch that's already occurred for the main contractor, accepting responsibility for the employer's requirements in the main contract. So for the employer, this then gives them a single point of responsibility in the guise of the contractor who has taken responsibility for the designs of typically the architect, the structural engineer and the building services engineer. And if things go wrong, the employer potentially only has to pursue the contractor, particularly if the other people were out of the picture. This is a big risk for the contractor, but they may decide to take this risk because the design team who's prepared the employer's requirements will typically be novated to them. So they will typically have a direct contractual link and recourse to the architect, structural engineer and building services engineer. There is no such direct link for the subcontractor, so they're being asked to be responsible for designs they've not prepared, and they have no link to designers to back this off as the contractor does. So this could also fall outside matters covered by the remit of the specialist subcontractors' professional indemnity insurance and outside of their competency in terms of the Building Safety Act, which I think is everyone's concern. Anyone wants to claim on the insurance, and it's not just for a risk for the subcontractor. Specialist subcontractors are very much experts in their field, but they're not architects. And they think the intention of the Building Safety Act is that professionals should stand by their own designs and their own competency. So if you use the standard form wording, the subcontractor takes responsibility for the design they've prepared, but not for the design of others. We could discuss that one all day, I think, on its own, but yeah, I think that's an important one to discuss first. Then on to scope creep. The case referred to in this slide deals with issues of scope as well as termination. And it brings in issues discussed in the previous slide where full design responsibility is accepted. So this case provides a valuable insight into the court's approach to the interpretation of complex construction contracts and serves as a useful reminder of the importance of clearly defining the scope of works. It also highlights the risks associated with termination, where the basis of the termination is disputed. So I'm relying on the interpretation here from Lexology and HFW in January 2025, which was extremely useful, this case. If you're into reading in more detail about legal proceedings or new legal developments, you can subscribe to Lexology. It will send you emails daily or weekly on topics of your choice, and there's some good case analysis and discussion with new legal developments on there. So BMP engaged Briggs under an amended form of the JCT design and build contract to remove an existing stair pressurization system and installed an upgraded system in a 30-story office building. Now, this was between an employer and a main contractor, but I think there's a lot of detail here which would also apply to a contractor and subcontractor relationship. The parties disputed the precise scope, particularly obligations regarding asbestos removal. It was common ground that there was asbestos in some relevant parts of the building, and Briggs' scope included at least some asbestos removal works. Specifically, the contract included 2 documents that identified asbestos in certain areas. There was a quotation from an asbestos removal subcontractor and a survey which informed the quotation. I think Briggs very much thought they'd restricted their works to that. But then when additional asbestos was identified outside those areas, highlighting the quotation in the survey, the parties had a fundamental disagreement on whether Briggs' original scope included addressing this. Did they have to perform certain further activities? Should they undertake further surveys to identify the presence of asbestos in the areas where it was found to undertake the works? And if it was found, do they have to undertake all those works necessary to remove the asbestos? So the contract didn't expressly identify the further activities as part of their scope. Briggs refused to perform these activities without a variation instruction. BMP didn't issue an instruction, and they argued that the works were implicitly part of Briggs' original scope. There was an impasse of over a year, during which the works ground to a halt. Briggs suspended the works, and then they attempted to terminate. They claimed that BMP's failure to issue variation instructions were preventing them from carrying out their works. BMP contended Briggs was not entitled to terminate. Then it eventually treated the termination notice as a repudiatory breach, which accepted, thereby terminating the contract and giving BMP a claim against Briggs. The court had to decide whether Briggs was entitled to terminate, and it decided that they weren't because the further activities formed part of the scope. It had to perform them and could not suspend pending a variation instruction. Now, looking at why the court decided that, that particular wording there is really important. There were several key features of the contract that confirmed that the works were part of the scope, including they accepted full responsibility to deliver the employer's requirements, which defined the scope of works widely. In particular, the employer's requirements expressly stated that the scope of the asbestos removal works included, but was not limited to, the removal of all the asbestos identified. And those qualifying words made it clear that Briggs' asbestos removal obligations were not to be read restrictively by reference to the quotation or the survey. The ERs also provided that Briggs' scope included all the incidental sundry components necessary for the complete execution of the work. Beyond the employer's requirements, the contract also allocated the risk of site conditions to Briggs, including any risk, contingencies, and all other circumstances which may influence or affect the execution of the works, which included presence of asbestos. The contract repeatedly stated that Briggs could not rely on any information provided by BMP. These included the quotation of the survey. So these are common enough things, site condition risks being passed over, these sort of all and sundry type wording. So the decision confirms that courts will, in certain cases, enforce broadly drafted terms. So terms assigning responsibility for the contractor for the entirety of design and construction of work, including items not expressly spelled out in the scope. So that goes back to the last point and the last slide, and kind of being made responsible for all and sundry, in that case, in the contractor's requirements. And also terms that push the risk of information provided by the employer onto the contractor, and also, remember, contractor to subcontractor, terms allocating full site condition risk to contractors or subcontractors. So those are kind of the things to avoid, and I'd say those specific kind of wording that we get here. And very important to consider this during contract negotiations, and whether you can accept this kind of risks, particularly important on complex projects where there's a higher risk of unforeseen conditions, conditions that may need specific attention. Always tread carefully as well with termination, and attempting to terminate where there's no entitlement to can seriously backfire, and the terminating party can find themselves defending a claim for wrongful termination. So a number of things to be really careful of there. On to third-party agreements. Again, by third-party agreements, I mean usually agreements that relate to the overall project, which are usually between the employer and another party, a funder, owner, local authority, or other vested interest in the project. The subcontractor, and usually the contractor as well, isn't a party to these agreements. And this is really belts and braces drafting by someone like me further up the chain to make sure that no obligations from these agreements slip through the net into the supply chain. So following on from the last discussion, it's really another scope creep item. So you think you've tightly defined your scope, you've considered the last slide, but then you see this clause: the subcontractor shall perform its obligations under the subcontract in such a manner as not to constitute, cause, or contribute to any breach by the contractor or the employer of its obligations under any agreement with the funder, any purchaser, tenant, or any other agreement entered into by the employer in connection with the main contract works, or to which the employer or contractor is bound, provided that copies or relevant extracts of such agreements are provided by the contractor to the subcontractor, so that the subcontractor is aware of the content thereof. The subcontractor shall be deemed to be fully aware of the obligations, risks, and liabilities assumed by the employer and the contractor under such agreements, and where copies or relevant extracts of any such agreements are provided to the subcontractor on or before the date of this subcontract, the subcontractor shall not have any entitlement to any extension of time or addition to the subcontract sum in connection with such compliance. If copies or relevant extracts of such agreements are provided to the subcontractor after the date of this subcontract and necessitate or result in an amendment to the contractor's requirements or employer's requirements, such amendment shall be treated as if it were a direction of the contractor affecting a variation. It's actually not the worst clause I've ever seen. So it does have at least the decency to say, well, you should be provided with the documents, and if you are provided with them late, then we might consider a variation. But this could be considerably improved by, for one thing, listing the actual third-party agreements by name and date. It just made general reference to them there. It can be all and sundry third-party agreements, anything to do with the funder or the purchaser, all those people that were included in that previous clause. It could state that the extracts could only be supplied and obligations are limited to that which is contained in the extract. So extracts are much better where they have to provide extracts which directly relate to your works, to your subcontract works. It makes the contractor do the work and sift through these agreements to actually provide it to you. It should say that these extracts should be provided by the subcontract base date. I think the last one, it was the contract date. By the subcontract base date, it's a specific date within a subcontract that serves as a reference point for assessing changes in the conditions affecting subcontractors' pricing, such as tax rates, site conditions, material costs. It determines the allocation of risk. So changes occurring before this date, generally the contractor's responsibility, those after, it's the subcontractors. This date allows for adjustments to the subcontract sum or time extensions if specified conditions change as outlined in the subcontract agreement. So it could say also that the TPA extracts should be included as numbered documents. So if they provide them by a certain date, they've got to be in the subcontract and not just included by reference. So you all know what's included, and state that anything provided after this date or any date that you agree between you may be a variation where additional or different obligations are required. So I think all this takes into account, it's about good communication and good provision of documents. I mean, if you were sent the designs early and you're all happy with it and nothing was going to change, then maybe you could accept that kind of clause as drafted before. But as we know, things get provided late. So by having these things in there, dates by when things have to be provided, that it's a variation if it's provided after, it sets your stall out and it makes sure that things don't, important changes really don't go under the radar and you aren't caught having to include other things, scope creep, as we previously said, and that you would get a variation for these things. So also on here, beware of pre-order meeting minutes and numbered documents in particular. This wording here was contained on a waste management form that was attached in the numbered document, so it's included in the contract on a steelwork contract. It's the obligation of the subcontractor to ensure that weekly conformance agreement is signed by the contractor authorised signatory on a weekly basis. The subcontractor must also ensure that the contractor receives one weekly conformance acknowledgement for each week. They are submitted for signature no later than 2 working days from the end of the week to which they relate. Any submitted thereafter will not be recognised and the appropriate reduction may be made. And it's a bit of a nightmare because even if you had basically removed the waste or whatever you had to do for that week, if you've not got this document together or the contractor not signed it, you can still have deductions made. And it could be deemed to be a non-conformance, and the contractor's got the final decision on the matter raised. So look out for things like this, deductions, contra-charges, important terms that can be included in the pre-order meeting minutes and in the numbered documents. It's a bit of a nightmare, to say the least. Also, sorry, speeding on a bit here, but indemnities. I bring this up, I think, in every contract talk I make because it can really widen your liability. So avoid in particular general indemnities for breach of contract, such as this one. The subcontractor shall indemnify and hold harmless the main contractor from and against all claims, losses, damages, liabilities, costs and expenses, including but not limited to legal fees and expenses arising out in connection with the subcontractor's performance or non-performance of the subcontract, including, without limitation, any negligent acts or omissions, breach of contract or infringement of any third-party rights, whether or not any such claims, losses, damages, liabilities, costs and expenses are foreseeable or unforeseeable. While this wording is common throughout contracts, you don't always see huge all singing, all dancing, main general contract breach indemnities such as that one, which are the ones to avoid. Maybe sometimes okay to accept certain ones, things that may fall outside general claims for breach of contract, such as IP is a common one. But I would say try and delete these clauses what you can, or try and mitigate it in some way. So I would say try and delete that clause altogether, or another way is to find any indemnity wording and individually amend each clause to modify the indemnity wording, although you do see sometimes 12 or more clauses in sets of subcontract amendments. So you find yourself doing a lot of individual amendments. I think sometimes a better way to do it, if you can get it through, is to modify or cap your liability. So you have a prevailing limitation of liability clause, and you also require any losses to be reasonable, foreseeable, direct and properly mitigated. So this means that the main contractor still has a remedy for breach of contract without the indemnity wording, but would just be limited to what they could be claimed at common law. So losses which are reasonably foreseeable, direct and properly mitigated. So it would just bring it back to the common law position rather than indemnity, which can extend your liability. Then on to 30-day payment, which is the final clause to be discussed today. And this term here, so we've got the example, the amendment at the top and the original clause at the bottom there in the example. So delete 14 days and substitute 60 days when the normal number is 14 days in the JCT contract. So in this project, the main contractor actually benefited. They had 30-day payment terms because it was a public sector contract. And they were also a signatory to the Prompt Payment Code. Just to remind you, both previous public contract regulations 2015 and the Procurement Act 2023 now mandates 30-day payment terms on public sector public contracts. So including throughout the supply chain, so to subcontractors wholly or substantially contributing to the performance of a public contract. But we're still seeing, because contractors are using their own terms, outdated lengthy payment terms in public sector project contract. And clearly an easy way to amend that is to bring the numbers down when you're negotiating, saying, look, this is a public sector project, there should be 30-day payment terms here. I just wanted to also mention that the government has launched a consultation on proposals which aim to improve cash flow through supply chains and support small businesses with payment disputes, and that's their late payment consultation, where views are welcome from all businesses, trade representative organisations, member organisations and interested parties. There are specific proposals referring to the use of retention clauses within construction contracts also, and government welcomes responses from those in the construction sector and wider who are parties to construction contracts. And we've actually got a member, this is a member only one, webinar next Tuesday at 4 p.m, where Emma Jones, Small Business Commissioner, and Nicola Walters, the Department for Businesses Trade, is going to speak to BCSA members directly about consultation. You can respond to the consultation on the online survey. the 23rd of October is the deadline, and inquiries go there to that email address. So the consultation is seeking feedback on a proposed package of measures which go further than any previous government on tackling late payment. We've been here before, but it's good to see that government are engaging, and particularly engaging directly with members, and that they want to look people to apply to the consultation. So they want to audit committee and board level scrutiny of large company payment practices. They propose to maximum payment terms of 60 days and a deadline for disputing invoices. So for the amending the Late Payment of Commercial Debts Interest Act 1998. They want to impose mandatory statutory interest, and they will be additionally reporting on statutory interest as well. They want to possibly impose financial penalties for persistent late payers, have additional powers for the Small Business Commissioner, including assurance of payment reporting data, and particularly with regard to construction contracts, they want to use retention clauses to potentially amend the housing grants, the Construction Act, basically to either prohibit use of retentions or to introduce requirements to protect retention funds deducted and withheld from insolvency and for late or non-payment. So that is my final bit of the discussion there. That's my final slide with the details on there. I'll just see if there have been any questions. I can't see any questions coming up. However, if you'd like to email me afterwards, please feel free to do so. Sorry, just go to the last one there. And thank you very much for joining me on the webinar, and I'm just going to bring the webinar to the close. Thank you.